In this episode, we talk about the 8 former personnel of the Indian Navy who have been handed death sentences by a court in Qatar. We also talk about creating a uniform identity card for all the students in India. But first, we talk about Telangana's stringent preventive detention law. Hi, I'm Rahel Philipose, and you are listening to 3 Things, the Indian Express News Show. With assembly elections a few weeks away, Telangana is under the spotlight for its stringent preventive detention law. It is a law that has led the state to detain the second highest number of people in the country as per the latest prison statistics. The state, at the end of 2021, had as many as 396 detainees under this law. And this is because just like other preventive detention laws, this one also allows the state to detain a person without a trial and a conviction by the court.
So a preventive detention is not the same as somebody being detained or somebody being in custody before the conviction happens.
That's the Indian Express's Apurva Vishwanath, who reports on the law for the paper.
That person is called an under trial. A preventive detention is when the state curtails your liberty and takes you into custody even without you having committed a crime. It is because a state thinks that you are likely to commit a crime or you have the potential to commit a crime.
And under such laws, the detention can be up to a year, unless of course it's extended. Now, when it comes to Telangana's preventive detention law, the reason why we've not mentioned its name yet is because it's pretty long.
Yes, it's probably one of the longest names of legislations that I've seen, and it basically tells you the ambit of the law itself. It's clear from the name itself what the state intends to do.
Its name has over 50 words and includes terms like bootleggers, dacoits, drug offenders, gundas, gaming offenders, cybercrime offenders, among others. In this segment, my colleague Shashank Bhargava speaks to Apurva about this law and the way the administration has been using it.
Apurva, begin by telling us who all has the Telangana government detained under this law.
So after the bifurcation of the state, we've seen that the numbers in Telangana really skyrocket. Of course, the number one spot has always been for Tamil Nadu for a while now. Telangana did a steep climb to the top after its bifurcation, which means there is intent on the state's part to effectively, in their sense, use this to say how the state feels that the law should be used effectively, which means they've detained about over 1,700 people from 2015 to 2019. And who've been arrested under this law? You have people for motorcycle theft, people arrested for chain snatching, people arrested for selling what are called spurious seeds or spurious fertilizers. You've had people being arrested for running online gaming rackets. Even an opposition MLA was arrested for making inflammatory speeches. When we look at a number of these judgments in the Telangana High Court and the Supreme Court, one clear pattern that emerges is the police uses this as a tool to address ordinary law and order situations. So where ordinary law is sufficient, but the accused does have some rights under the law, so he might be able to get bail or, be acquitted, then the state uses the preventive detention law to keep them in custody for some more time. So it's more of a band-aid solution, which is buying time to solve real law and order situations in the state.
Right. So even where a regular law would apply, the state is using this instead because it gives it more powers. But Apurva, when it comes to such preventive detention laws, what is considered a reasonable way for the state to use them?
So, Shashank, like we've talked earlier in the context of, say, the UAPA or the Enforcement Directorate's powers, the preventive detention regime is an alternate legal system, right? It is not the same as our ordinary laws where you are considered innocent until proven guilty. Preventive detention is a colonial relic, something that the British used in India, but there is some wide consensus on retaining this law. Not just in a separate legislation, but mandating it in the constitution itself. So there is this considerable debate in the Constituent Assembly, and the framers of our constitution felt that preventive detention should actually be mentioned in the constitution itself. So we often talk about the reasonable restrictions that the constitution allows the state to have on our fundamental rights. But preventive detention is a much higher restriction, and it is mentioned in the Constitution itself. So where the state comes from, this is a preventive tool. This is to ensure crimes don't happen. But of course, this is an extraordinary legislation meant to be used sparingly, meant to be used only in such extraordinary circumstances where it is warranted, say to prevent a riot, for example, or things like that. But what we see happening in Telangana is the use of this law to circumvent ordinary law. So if an accused is entitled to bail under ordinary law, say there's a repeat offender with chain snatching, right? Instead of securing a conviction, the prosecution working hard to secure a conviction and actually having him sentenced for whatever the law allows, what the state is doing is using the preventive detention law to just extend his stay in the jail.
Right, and most of the states in the country actually have some version of this law. But what would you say makes the Telangana preventive detention law so unique?
So what is unique about this Telangana law is it is perhaps the most extensive legislation for preventive detention. It covers a whole spectrum of offences, including a lot of ordinary IPC laws, which is, say, for example, sexual assault, criminal conspiracy, assault. All of these also form part of offences for which you can be detained by the state.
And you mentioned that people have been detained under it for stealing motorcycles, for example. Could you talk about that particular case?
So this 2022 case is a very illustrative example. This man called Ananta Ganesh is arrested for the theft of 6 motorcycles. So from sometime in October 2021 and November 2021, within that month, there are reports of 6 motorcycles stolen in a neighborhood in Hyderabad, and which means there are 6 separate FIRs, and this man is identified as the accused and has been arrested. Over the course of time, because this is a motorcycle theft, is a petty offense, which carries a sentence of less than 2 years. So over the time, courts have granted him conditional bail in all 6 cases. Subject to certain conditions, he would have been released on bail. So the state thinks he's a repeat offender and would probably go back to motorcycle theft after his release from jail. So what they do is invoke the Preventive Detention Act. So under the Preventive Detention Act, they categorize Ganesh as a gunda. A gunda is a defined term under the Act and says he is likely to cause widespread fear or panic amongst people because of his history. And it's the same 6 cases for which this man got bail that form the grounds of his detention order, which is clearly just a tool to circumvent his bail orders. Shashank, here you have to note that the state lost the bail cases. The state would have definitely argued against granting of bail, and the court granted bail. And bail is the norm in such cases. It's not a heinous crime. So bail is the norm, and keeping someone in prison is the exception. So here, we don't know how the state argued the bail cases, but once he gets bail, the state uses the PD Act to keep him in jail. So he must have gone from being a UT, that is an under trial, to being a PD, that is a preventive detainee.
Right, and this motorcycle stealing case was one example. But you also mentioned the case where a person was detained for selling fake seeds. Actually, we don't really know if they were fake or spurious, right?
So that is the distinction in this legislation. Like you said, we don't know if there are spurious seeds, right? That is something you will learn only when a court of law tries him and convicts him. So till that point, you don't know whether this man was selling reasonably good quality seeds, which resulted in a bad yield of the crop, or if he was actually deliberately selling spurious seeds. That is something a trial under ordinary law will have to determine. But under the Preventive Detention Act, what happens is just on mere suspicion. This is how the innocent before proven guilty reverses. That's how it works in the Preventive Detention Act. That the state realizes that there is a likelihood of this man being released on bail. So they invoke preventive detention against him. This again is something that the court struck down as measure that was taken very callously by the state. But what happens in preventive detention is that, like in many of these cases, process is the punishment. The man would have already spent his preventive detention time in custody by the time he moves the High Court and then the Supreme Court and gets bail. So preventive detention usually happens for a period of 1 year. It is not sanctioned by a court of law. Till you challenge it in a court and the court approves or rejects it, it is done entirely by the state. The police books you for preventive detention or the district magistrate, and then an advisory board which is set up by the state itself approves the police orders and, you're in custody. So now when you move the High Court, we know that the average time a High Court takes in cases like this is a few months. So by the time you go to the High Court and this process has happened, you've spent some time in custody. So even if the High Court strikes down the preventive detention order, there are no strictures passed against the police, for example. There is no compensation for that person. So there is no disincentive for the police to not book anyone under preventive detention left, right and center.
And Apurva, has the Supreme Court or the Telangana High Court taken cognizance of this law? Have we heard anything from them?
So here we'll have to tell our listeners that judicial review is very limited when it comes to preventive detention because constitutionally mandated idea. So the courts can only look into whether the advisory board has applied its mind, whether, they've considered all facts, and a lot of these technical procedural grounds have been followed, which means that, the advisory board has decided the case on time within that 3-month framework that they have. Or if they have, read the grounds of the detention to the detained person in a language that he understands. So the court can only look at these basic things to determine whether a detention order is legal or illegal. But we've seen a lot of detention orders being struck down by the Telangana High Court. But again, like I said earlier, the Telangana High Court is not passing strictures against the police. It says this detention order is illegal, but there's nothing stopping the police from doing the same thing in another case. But the Supreme Court, what we've seen is sort of highlighted this issue in many of its judgments. And this is not just one bench. There are 3 different benches which have looked at Telangana cases. And when they look at what sort of cases are coming before the Supreme Court, each of those benches are highlighting that this is a problem in Telangana. So the latest judgment we saw was in the first week of September in the Supreme Court, where in fact the Supreme Court underlined that there's this pernicious trend that is prevalent in Telangana. And the state is callously using this draconian law. So the Supreme Court's now taking notice of this issue and red flagging these cases.
And Apurva, besides this, we don't hear a lot about these cases from the courts and even otherwise. Does that have anything to do with who all are being detained under it?
Yeah, so like the Advocate General of Telangana told our newspaper, it's not as if all of these detained people are Mr. Cleans. So these are people who have a criminal history. You can imagine in the case of people arrested for petty theft or, smaller crimes like that, the wherewithal to actually go to the High Court or the Supreme Court and file a habeas corpus. It's a lot of money and investment of time. In those cases, there are a lot of cases which may not even reach that stage. It's easier to spend 1 year in jail and get out rather than spend money to go to the High Court and Supreme Court where you may or may not get relief. So that is also a problem when it comes to who is being booked under this law. And generally, the criminal justice system does look at people with a checkered history in a certain way, right? When you are an accused, there is already that shadow of criminality on you. So these orders from the courts where detention orders are being struck down, they are so unrelatable for the court. They have to be so unimaginative on part of the police that the courts have to strike it down.
And next we talk about 8 former Navy personnel in Qatar. Last week, a court in Qatar issued death sentences to 8 former personnel of the Indian Navy, a ruling that India has described as deeply shocking. Now, this comes more than a year after Qatar detained these individuals in connection with an alleged espionage case. Sometime back when we had spoken to Nirupama Subramanian, the former national editor for strategic affairs at the Indian Express, she had told us about the naval officers and what they were doing in Qatar.
They are ex-Navy, Indian Navy, and they were working for a company called Dara Global Technologies and Solutions, which is a service provider to the Qatari Emiri Naval Force. That's the full name for the Qatari Navy. And this company was providing all kinds of services. It was involved in the training of the Qatari Navy. It was involved in maintaining equipment. It was involved in providing logistical services. And the company was very well known in those circles. In fact, one of the people who is in custody, Commander Purnendu Tiwari, he was awarded the Pravasi Bharat Samman award in 2019 for furthering the bilateral relations between India and Qatar. because of the role that he was performing as part of this company.
And while they were working for Dhara Global, these men were picked up by the Qatari authorities last year in August.
It's not just normal jail. Each of these men has been put in solitary confinement. And solitary confinement is very severe punishment. You don't give solitary confinement as a punishment for ordinary offenses. It is usually associated with security offenses. And security offenses meaning, betraying the nation in some way or the other, or espionage, spying. This kind of thing usually attracts solitary confinement. So solitary has triggered the speculation that, and given the kind of work that they were doing, which was with the Qatari Navy, it has triggered speculation that they were involved in some kind of espionage. Now, no one has said that formally. The Indian government definitely has not said that. When this question has come up repeatedly at the weekly briefings of the Ministry of External Affairs.
Now, since their arrest, the Indian mission in Doha was given consular access to the imprisoned men.
Now, what consular access means is that a diplomat in the mission there goes and meets the person or persons who are in jail. And, there is some conversation between them. The primary purpose of consular access is to find out their well-being as well as, whether they need any legal assistance. Also, it's an opportunity to find out what actually went wrong. I mean, what are they accused of or what's going on?
Nirupama had told us that what makes this entire case so puzzling is that despite granting consular access to the detained Indian nationals, the Ministry of External Affairs was not clear about the charges against them. And what makes this matter even more complicated is that Qatar, which has friendly ties with India, did not notify the Indian mission immediately after their arrests.
Because in a country with whom you have friendly relations, this is routine. Somebody gets arrested, especially if it's a security-related offense, they would be informed immediately and they would be told quickly what the charges are. So it's a little puzzling that Qatar has not yet done that. In fact, that it took them so long to inform the Indian embassy in Doha that, these men are in their custody. And then it took them a further 2 weeks or so to give them the first round of consular access. So it's a little surprising that this has happened with a friendly country. One can imagine that something like this would happen with Pakistan. Like if they capture somebody who they allege is a spy or for any offense, it is likely that they will not inform the Indians immediately.
And last year, when External Affairs Minister S. Shashank was asked about them in the parliament, he said that this was a sensitive matter and that they are in constant touch with the Qatari authorities for it.
I can only say, because their interests are foremost in our minds, I can only assure him we have been seized of the matter. Our ambassador, senior officials have been in continuous touch with the Qatari government on this. Our effort is obviously to ensure that they are not treated unfairly and that if the sooner we can bring them back home. So I assure you that they are very much, very, very strongly in our priorities in respect of Qatar.
Since then, the men have been relocated from solitary confinement to a jail ward in Doha where they share double-bed accommodations. But the news of the death sentence has come as a shock to the family members of the 8 men and to India. The Indian Express's diplomatic affairs editor Shubhajit Roy had recently reported that Delhi is exploring various legal and diplomatic options for the Indian nationals. These options include reaching out to top legal experts in Qatar, such as a former government counsel in a top Qatar court, to appeal the sentence. The Indian mission in Doha is also looking at the charges and the basis upon which the court issued this verdict. And as we had mentioned earlier, Qatar had never clarified the charges against the 8 men, which has further added to India's legal challenge. Additionally, India is pursuing a mercy petition to Qatar's ruling emir, Sheikh Tamim ibn Hamad Al Thani. Now, India and Qatar have maintained friendly diplomatic relations over the years. In fact, more than 8 lakh Indians live and work in the Arab nation. However, when we had spoken to Nirupama, she expressed concerns that this incident could strain the relationship between the two countries.
from 2008 onwards, when Prime Minister Manmohan Singh was the first Prime Minister to visit Qatar, there have been a lot of developments. And defense cooperation is described as one of the pillars of the bilateral relationship. And it involves training. Basically, it's all about naval cooperation, and the agreement specifically involves training. A defense cooperation agreement was signed in 2008 during Prime Minister Singh's visit. And that agreement specifically mentions training as one of the elements of that agreement. And this involvement of ex-Indian Navy officers was also seen as part of that cooperation. So yeah, it's come as a bit of a surprise, and it's worrying for that relationship, because it means perhaps that we have not been able to tap the right levels of the Qatari leadership, perhaps.
And in the end, we talk about a new student iCard. Last week, several state governments requested schools to seek parental consent for the creation of a new student identity card known as the Automated Permanent Academic Account Registry, or APAR. Now, this new ID card is part of the centre's One Nation, One Student ID, which was also part of the National Education Policy of 2020. But there have also been growing concerns about this new ID card. Some students and parents have been hesitant to share their data because they worry that their personal information could be leaked to outside parties. The Indian Express's Vidheesha Kuntamalla joins us in this segment to talk about the APAR ID and its implications for students and schools across the country. So Vidheesha, can you start by explaining what exactly this APAR ID card is?
So APAR, which stands for Automated Permanent Academic Account Registry, is envisioned as a special ID system for all students in India starting from childhood. This includes learners from both lower education and higher education. Under the initiative, each student would get a lifelong APAR ID, which is unique and authentic, making it easy for learners, schools, and governments to track academic progress for pre-primary education to higher education. APAR would also serve as a gateway to DigiLocker, which is now EduLocker, a digital system where students can store most of their important documents, certificates, achievements such as exam results or report cards digitally, making it easier to access and use them in the future for pursuing higher education or for finding a job. This was basically envisioned with an aim to reduce the burden of students carrying around physical documents or storing physical documents by making everything digital.
Right, but how exactly will this ID work? How will it benefit the students?
So APAR aims to reduce fraud and duplicate educational certificates also. So by providing a single trusted reference for all educational institutions, only first party sources that issue certificates, like any educational institution or organization who has the authority to issue these certificates, will be allowed to deposit credits into a system of a student. So every individual will have a unique APAR ID which will be linked to their Aadhaar, and when a student completes a course or achieves something, it's digitally certified and securely stored in his or her account by authorized institutions. If the student changes schools, whether within the state or to another state, all the student's data in the ABC, which is the Academic Bank of Credits, gets transferred to his or her new school just by sharing this simple ID. They won't have to go through the hassle of providing physical documentation or transfer certificates again.
Right. And Vidheesha, can you tell us how exactly one registers for this ID card?
So to sign up for an APAR ID, students will have to provide basic information such as name, age, demographic information, date of birth, gender, and a photograph. And all of this information will again be verified with the student's Aadhaar number, which ideally they'll have to provide because the APAR will be linked to the Aadhaar. So there is a consent form in which a student is supposed to give consent to the Ministry of Education, saying that they are willing for the ministry to access their personal information through Aadhaar to verify the authenticity or the uniqueness of an individual. So for minors, the same consent form will be signed by parents, which again several state governments have circulated last week, asking parents and students to sort of sign this consent form giving their permission to, enroll for the APAR ID and for them to access the students' information. For now, it's not compulsory, it's not mandatory, it's a voluntary choice. That is what the guidelines of the Ministry of Education state.
So do we know how many students have signed up so far, and where have most of these registrations taken place?
So currently about 2 crore students have registered for APAR ID, and most of these 2 crore students are students of higher education. The ministry has been pushing, they are aiming to sort of get about 30 crore students. The target is to get about 30 crore students to register more, and there is a push to sort of make more students from lower education, from schools, to register for APAR ID.
And Vidheesha, we understand that there are some concerns regarding this ID, particularly considering the fact that this initiative essentially asks for data about crores of kids across the country. So could you talk to us about the kinds of concerns this has raised?
So when the consent forms were circulated last week in several states, even though the guidelines of the ministry said that, the information will only be used for verification purposes and the information won't be shared with any third party except for a few entities engaged in educational activities, such as the Unified District Information System for Education, which is the UDIS database. This is the government's catalog that contains data related to schools, teachers, and students. Even though the ministry has said that in its guidelines, parents and students still have concerns about sharing their Aadhaar details because they worry that their personal information could be leaked somehow to outside parties. So the guidelines again say that at any given time, students have the option to stop sharing their information with the mentioned parties. However, they've also mentioned that any personal data which has already been provided and processed will remain unaffected if consent is withdrawn. So we've also spoken to many teachers and principals in Delhi of several schools, and there seems to be a lot of confusion also around APAR ID. The first question that many of these teachers and students and principals are also asking is that why do you need something like the APAR ID? Because there's already a lot of database about a lot of students, teachers on the UDIS platform, which is linked to your, which again has information from your Aadhaar. And also there is no clarity as to whether a student or a parent can say no to this consent form. There hasn't been any proper orientation given to any schools as to how to implement APAR ID. So it's just a basic instruction which was given to all these schools that, this is a consent form and you should ask students or their parents to sort of sign it.
You were listening to 3 Things by the Indian Express. Today's show was edited and mixed by Suresh Pawar. It was written and produced by me, Rahel, Philipose, Utsa, Sarmin, and Shashank. If you like the show, then do subscribe to us wherever you get your podcasts. You can also recommend the show to someone who you think will like it. Share it with a friend or someone in your family. It's the best way for people to get to know about us. You can also tweet us at the Express Podcasts and write to us at podcasts@indianexpress.com.